For today's United States Supreme Court case, we turn our attention to civil RICO, racketeering influence corrupt organization. So this is basically the mob. And there is a civil course of action in RICO. Now, federal courts hate civil RICO because people overuse it all the time. People use civil RICO as a I just am really angry button, to the point where most federal courts require specific pleading in RICO cases. Normally, in federal cases, you can just do what's called general pleading. You don't have to list out everything in excruciating detail. In RICO cases, not so much, because they have been so overused, so misused, that most federal courts are like, screw it, I want specific pleading. And you have to actually lay everything out in excruciating detail. So they really, really hate it because it is way, way overused. But it does exist, and maybe occasionally is true. So in this particular case, we are trying to turn our attention to whether interference with an intangible asset qualifies as a predicate for RICO. So if you are interfering with someone's intangible thing, does that qualify as one of the predicate acts for the racketeering influence corrupt organization? And it turns our attention to two Russians, because of course it does. So this is the case of Yagazarian, also known as Egazarian, versus Smegan. Two Russian people who were involved in some sort of RICO-related thing. We'll learn more about their malfeasance and all their fun activities with each other. Let's learn more about this. The respondent, Smegan, won a multi-million-dollar arbitration award in 2014 against the petitioner, Yagazarian, stemming from misappropriation of investment funds in a joint real estate venture. We're buying some real estate. We're putting some money to buy the real estate. You have taken the money not to buy the real estate, but for other reasons. You have misappropriated the money. You have stolen from me, sir. This was money to buy the real estate, and you didn't do that. Okay. Because Yagazarian lives in California, Smegan, who lives in Russia, filed suit to conform and enforce the award in the Central District of California, pursuant to the Convention of Recognition and Enforcement of Foreign Arbitration. So this case was initially heard overseas, I presume in Russia. And there was an arbitration, presumably pursuant to some sort of contract between them. But whatever, there was some sort of proceeding in Russia relating to their joint investment venture, in which one guy apparently stole from the other guy, and apparently the one guy got an award from the arbitration in Russia. So he files in California for enforcement of his judgment and said, here is my Russian arbitration award. Please enforce this in the United States so that I can get the money which is in the United States. Okie dokie, fine. The district court initially froze the California assets before finally entertaining judgment. So California's over here like, okay, fine. I recognize this foreign arbitration award. Looks good to me. I freeze your assets. I give judgment. Go take the money. Fantastic. The district court also entered several post-judgment orders barring Yagazarian and those acting as direction from preventing collection. Hey, you, bad guy. You can't do anything that prevents him from taking judgment. I don't know what that would be necessarily, moving money out of the country or whatever, right? So I've frozen your assets. I have given judgment, and I'm also giving further orders preventing you or anyone else from interfering with this judgment. This judgment will be enforced in this great jurisdiction of ours. Suck it. Fine. While the action was ongoing, Yagazarian himself was also awarded a multi-million-dollar arbitration award in an unrelated matter and sought to avoid the district court's asset freeze by concealing the funds, which are ultimately transferred to a bank account with the petitioner. All right, so we've frozen some money that is related to this particular dispute or other assets of the guy, right? He comes into district court. We have an arbitration judgment, says, give me money. We go to district court, says, I'd like you to enforce the order to give me money. District court says, fine, here's an order, give him money. I'm also freezing your assets. Go take the money. It's your money. Following this, the guy who we have filed suit against has gotten more money. He's gotten money. Yay, money. So those are now other assets that now exist. Hey, those assets could also be used to satisfy the judgment. But that money, he lied to the court about its existence and tried to transfer it around or something so, it couldn't be used to collect against the judgment. So he's trying to, the court said, you don't play games with us, and he's playing games. Fine, let's see. So in 2022, Megan over here files a RICO relating to this. All right, so we've now escalated things. We've used the I really dislike this button and said, okay, by you defying the court order that said, don't play games with the money, and you moved money around so that I couldn't get money, you have violated RICO. So let's RICO your assets. That's fun. So the RICO provides a private party right to any person injured in business by reason of RICO. So you are a mob. You are the mobster. Okay. So it's the Russian mafia, I guess. We're suing the Russian mafia. Okie dokie, let's give that a try. As relevant, Smagan alleges that Yegazarian and others worked together to frustrate the collection on the California judgment through a pattern of wire fraud and other predicate acts. Yeah, okay, so we moved money around, we did a little banking fraud, we did a little wire fraud, we lied to the court, we did a couple racketeering-related acts, we needed a couple of them, we got a couple of them, we have the RICO, they say. Okie dokie. The district court dismissed the complaint probably because they really secretly hate RICO and are looking for really any reason to dismiss RICO, because that's probably the real reason. So I know the Supreme Court's about to tell us the reason the district court dismissed it, but the real reason is district courts hate RICO because it's so overused and they're so tired of this bullshit. So the real reason they dismissed it is because they hate it, because it's bullshit almost all the time. So the district court ostensibly dismissed the complaint on the ground that Smagan had failed to plead a domestic injury as required by a different U.S. Supreme Court law. So the problem is that you didn't suffer your injury in the United States. All right. This is all relating to some dispute that occurred, and it was arbitrated in Russia. So the injury fundamentally is Russian, not US. I know the court gave an order in the United States, but the underlying injury was actually Russian. So this does not have anything to do with the United States at all, says district court, looking for any reason not to hear the civil RICO because U.S. district courts hate civil RICO. Smagan's Russian residency weighed heavily in the district court's decision. I bet it did. I bet it weighed real heavily. The Ninth Circuit reversed, rejecting the district court's rigid residency-based approach to domestic injury inquiry. The Ninth Circuit instead applied a context-specific approach and concluded that Smagan had pled domestic injury because he alleged that his efforts to execute on the California judgment in California against California residents were foiled by a pattern of racketeering activity that largely occurred in California. So the problem was him, messing around and moving the money and playing games and all this stuff, which is an intangible injury, right? Because the problem was him doing these things which didn't really hurt me in and of itself. It just prevented me from collecting on a different judgment. So the judgment is for money, but this is more intangible in its nature. Okay, so is the intangible injury enough? All right, the U.S. Supreme Court holds a plaintiff alleged domestic injury for the purposes of RICO when the circumstances surrounding the injury indicate it arose in the United States. Yeah, sorry, district court, you might actually have to hear this one. The district court hates their life a little bit. We're going to actually have to hear this RICO. I feel the district court is begrudging its existence a little bit right now. But yeah, you might actually have to hear this case. The domestic injury requirement for the private RICO stems from a case of RJR Nabisco, in which the court is asked whether RICO applies outside the United States. Does RICO apply outside the United States? To answer the question, the court applied the presumption against that. So normally, we don't read laws to have effect outside the United States unless it's clear that they want to apply outside the United States. There are some laws that apply outside the United States, but we presume against it unless Congress indicates clearly otherwise. Guided by concerns of international comity, we'd like all the countries to get along and be friends, and reasonable discernment of congressional intent, we think Congress is a smart Congress and this is what they wanted. The court distilled the presumption against the foreign application into two steps. The first asks whether the statute gives a clear affirmative indication that applies. Did Congress, which is a smart Congress, indicate that they want this to apply outside the United States? If that answer is yes, then great. If the answer is no, the inquiry proceeds and asks whether the case involves domestic application of the statute, which is assessed by looking at the statute's focus. So is there some domestic component to this? Does Congress want it to apply against in the whole world? Is there something that attaches this into the United States? Okie dokie. Applying this framework, the court assessed the foreign application of RICO and determined that it does not overcome the presumption in step one. So as to RICO itself, Congress was not clear they wanted this to apply to the outside the United States. It could have been, but they didn't. So they didn't say that this extends outside the United States. Okie dokie, only United States acts qualify. Fine. Proceeding to step two, the court held that a private RICO plaintiff must allege and prove a domestic injury to the business or property. Only United States counts. Fine. Because RJR and Nabisco plaintiffs were not seeking redress for any domestic harm, the court did not have occasion to explain what would be a domestic harm. So in RJR and Nabisco, the only claims were for foreign. And they said, no, you can't do that. You can't do the only foreign. It has to have some tie to the United States. We presume that Congress doesn't want laws to apply outside the United States because the United States is aware that other countries in the world exist. And if laws apply outside the United States, that might step on other countries' toes, and they might be a little bit grumpy about it sometimes. So we recognize the United States can kind of do what it wants as a sovereign nation, but we want to be like, are you sure? Are you really sure? Are you really sure you want to do that? Because, other countries might be grumpy and all. But if you want them to be grumpy and all, well, okay, that's fine. You can do that. But in this case, in RJA and Nabisco, you didn't do that because it was only foreign and you weren't clear. Fine. Let's find something domestic or go away. Great. The parties advancing the competing approaches to the domestic inquiry. Petitioners urge a blight rind rule that locates a plaintiff's injury at the plaintiff's residence. They argue that because private RICO actions remedy only economic injury, and plaintiff necessarily suffers that injury at its residence when the economic injury is felt, any injury is necessarily suffered at the residence. So RICO is to remedy you've been harmed financially. They argue that all harms that occur to you financially necessarily occur to you where you live. You feel it in your pocketbook, and your pocketbook is located at your house. And so all injury that RICO could possibly do is at your house. And since this guy's house happens to be in Russia, therefore all injury is Russian. There is no U.S. injury, says these guys. Okay, let's give that a try. Additionally, petitioners argue that at least where intangible properties occurred, common law principles locate the intangible property at domestic residence, such the injury is also located there. Smagan defends a contextual approach. Okay, so for intangible things, then it has to be at your residence. So maybe if this is some real property or something, or this is an asset that is like a car or something, right? We could look to the location of the land. We could look to the location of the car. We could look to the location of the thing we interfered with. So first idea, all injury occurs at your home. All injury is your pocketbook. Your pocketbook is at your home. All injury occurs there. Okay, if you don't like that idea, how about all intangible injury occurs at your home? So maybe if it's a car, maybe it's a piece of land and the injury is there, we can look to where the land or the car is located. But if it's intangible, where is it? Where is it? It's out there in somewhere in the ether, right? And so maybe the injury only occurs at your home, which there is some precedent to define that concept, right? When we look to intangible injuries, for example, defamation, we often look to where the person is located. So the idea that all injury, or at least a place of injury, that a person might suffer intangible harm is where they live, right? So if we're looking at defamation, for example, by just picking something that we can contrast this with, right? If we're looking at a place, where is the injury occurring? The injury might occur where you live. So that is at least a place of injury. So when we think about RICO, we're going to say all injury for the intangible occurs where they live. The other guy's like, no, I don't like that rule because it would prevent me from suing. So we'll look to something a little bit more contextual rather than a bright line. So a bright line, all injury at your house. Context, it depends. So are we going to go with bright line or it depends? You already know the answer to this question, right? Is the answer going to be it's really clear, or is the answer going to be it depends? We all know the answer to that question before we even ask it, but let's press on. The court agrees with Smagan that it depends is the right answer and largely turns on facts alleged in the complaint. Specifically, the court should look to whether circumstances surrounding the injury to assess whether it arose in the United States. So, yeah, it depends. We don't like the bright line rule very much. So we're going to look the context. We're going to look the things that might suggest the United States is involved in a more potentially ambiguous way, and things become fun and the lawyers get paid. Yay. Here, the means of looking to the nature of the alleged injury, which is the racketeering activity that directly caused it, and the injurious aims and effects. So here, the activity for the RICO occurred in the United States because the bad guy is located in the United States. The judgment is located in the United States. His bank accounts are at least partially located in the United States. So enough United States for us, says the Supreme Court. The context-specific approach is most consistent with our common law. The court's statements in RJA Nabisco that domestic injury requirement does not mean foreign plaintiffs may not sue under RICO. The domestic court is very sad. The district court is sad because they prefer not to do this. An application of the rule in any case will always not be self-evident. Point towards a case-specific inquiry that considers particular facts. And every district court breathes a heavy sigh and hates their life a little bit more. That approach also better reflects the requirement's origins in step 2, which assesses whether there's a domestic application of a statute by looking at the statute's focus. RJA Nabisco implied that a focus is injuries in business or property by reason of violation of substantive provisions. So understood, the relevant focus is not on isolated injury, but injury as product of racketeering activity. So we're not looking to the exact injury that exactly occurred, but we're looking more to the process, because RICO, after all, really is more about process because you need multiple predicate acts. So in some sense, in RICO especially, it doesn't make sense to talk about the specific thing, because in RICO, there is not a specific thing. There can't be a specific thing because RICO requires multiple predicate acts. So there are multiple things. So we are looking in a more nebulous sense about RICO, and every district court secretly hates their life. This requires courts to look to the circumstances surrounding the injury to see if those circumstances sufficiently ground the injury in the United States. Yay. The circumstances surrounding this injury make clear the injury arose in the United States. Smagan's alleged injury is his inability to collect his judgment. Much of the alleged racketeering activity that occurred in the United States because bad guy is in the United States. And while some of Yegazarian's scheme to avoid collection occurred abroad, the scheme was directed towards frustrating the California judgment. So yes, it is true that some of his activities occurred in Russia, perhaps all of them, for all I know. Maybe he has no U.S. bank accounts. But the U.S. Supreme Court's like, we don't care, because this is all designed to frustrate a Californian judgment. So maybe everything is foreign, but it's domestic enough. Lol. The alleged RICO scheme thwarts those rights, thereby undercutting the orders of the district court and Smagan's efforts to collect on the assets in California. Under the contextual approach, the allegations suffice to state domestic injury. Yeah, so you had a California order from a California court for a California judgment, and we really don't care about the rest of the details. It's domestic enough. So did he have bank accounts in the United States? Did he do the wire fraud in the United States? We literally don't care. Probably the answer is yes, but also we don't care because it's fundamentally to all thwart a domestic judgment. So literally, if everything else occurs overseas, we don't care. It's domestic enough. Exciting. Petitioners argue the contextual approach is inconsistent with certain common law principles, giving the situs of injuries to intangible property, which, fair enough. They're not completely wrong. We can talk about that, right? The situs of injuries in intangible property. Yeah. So when we look to tangible harms, we often look to where the victim's location is. So them saying this is incompatible with the common law is not an invalid argument in the first instance. They might be right that that's true. So are we going to either say this is different in the common law, or are we going to say RICO modified the common law? Which way are we going to go? Let's see. Specifically, petitioners point to the restatement of conflicts of law under which fraud is typically deemed to be felt at the plaintiff's residence, and under the principle of mobilia sequentur personam, which generally locates intangible property at a domicile of the owner, and argues the principle locates the alleged injury at his residence. This is a perfectly valid line of argument. This is a legally cognizable and cogent argument. It's a very good argument, incidentally. So the Supreme Court has to overcome this a little bit. Now, they can do this in one of two ways. They can either say that this is not a universal rule and look to instances in the common law in which it's not true. So that's option one. You've overread the common law. The common law supports this too. Or option number two, RICO overrules the common law. So which way are we going to go? Let's find out. Petitioners fail to explain the relevance of these principles and show that they were principles asserted at common law at time of RICO's enactment. I don't know. They fail to explain the relevance. I don't know. I think they're pretty relevant. And you say that they weren't clear at the time of RICO. I don't know about that one either, Supreme Court. That seems like a dodge to me. The core problem with petitioners' reliance on legal fictions concerning the situs of injuries in other areas of laws is justification of that approach do not necessarily translate to the presumption against extraterritoriality with its distinctive concerns for comedy and discerning congressional meaning. I don't know about that one. Okay, so I don't really like this middle sentence here where it's like, they don't explain the relevance. I immediately understand the relevance. I get it immediately. So the Supreme Court's saying we don't understand the relevance. I'm like, are you sure? Because I understand the relevance immediately. And you say it's not established at the time of RICO. I'm like, I kind of think it is. So I don't really like that sentence. The next sentence is slightly better. They say the problem with that is that by saying that all injury occurs at the person's residence, which is the common law rule, which we're going to ignore, but if it was the rule, which totally is, but we're going to say it's not, the problem is if we did that, it would go against the presumption of extraterritoriality, because that would mean that the injury occurs in Russia, which I don't think that really works either, to be honest, because it is often true that injury occurs in the foreign country. And that's one of the very reasons that the United States has this presumption against extraterritoriality in the first place, right? If the injury is really a Russian injury, then the principle of extraterritoriality says, yes, recognize that it's Russian, and therefore it's Russian, and therefore the court should stay the hell out of it. So if you want to say this is really a U.S. injury because the judgment is in the United States, and that is the problem, then I understand that. But to say that it's a legal fiction, what? And to say that it goes against the presumption of extraterritoriality, no, I think it's kind of the exact opposite way around on that one, Supreme Court. So you're losing me a little bit here in the middle part, I have to be honest. Indeed, petitioners' approach generally results counter to comedy and far afield from any reasonable interpretation of what qualifies as domestic interpretation. Really? So you sure? I don't know, man. I think that you're basically wrong. I think that the exact opposite is true. I think that their argument actually respects comedy more than yours does, because their argument is this occurred in Russia. You should say this is Russian, and this is a Russian problem to be dealt with by Russia. And comedy, all the countries should get along and play nice with each other. And extraterritoriality, the United States should stay inside its own lane, should recognize that this injury occurs in Russia. Let it be a Russian problem. And you say this is far afield from any reasonable interpretation. No, it's quite reasonable, and actually arguably the most reasonable. I think you can get past this by noting that there's a United States judgment and saying, okay, that's domestic enough. I kind of buy that. But to ignore the fundamental underlying thing that this is Russian based on principles of common law, which you say aren't well established, which they totally are, and you say they fail to explain the relevance, and the relevance is immediately obvious. I think you are being a little bit intellectually not quite conforming to the understanding of the law here. I think you're playing a little cute here in the middle. Consider two U.S. businesses targeted by racketeering activity. one owned by a US resident and one owned by someone living abroad. There's no evidence that Congress intended only the former business owner can bring suit. Yes, there is. You just said there was. 5 seconds ago, you did. You said, when looking at RICO, you just said, do I have to quote you from 3 paragraphs earlier where you said exactly this? There's no evidence Congress intended only the former? Yes, there is. You said very clearly that RICO is not extraterritoriality. You said it is not meant to apply outside the United States. Now you're saying there's no evidence that they only wanted the one business owner to apply suit. Yes, there is. Did you not read what you wrote 2 paragraphs ago? What? Okay. Especially since doing so runs the risk of generating international discord. No, I think kind of maybe the reverse is true, to be honest. I think maybe the exact opposite of that. This means the United States can get more involved in more affairs involving foreigners, which perhaps it should, but it doesn't really conform to what you said about RICO 3 paragraphs ago, and it doesn't really conform to the common law. I mean, there's a way to get past this, but this isn't the way to do this. Finally, petitioners argued that the context approach is unworkable because it doesn't provide a bright line. Such concerns about fact-intensive tests cannot displace Congress policy choices. But you said their policy choices were the other way around. Did you not read what you wrote? Where a more nuanced test is true to the statute's meaning. Affirmed and remanded. Thus, that brings us to the end of the case of Yagazarian, also known as Egazarian versus Smeagol, in which we determined that RICO applies anytime there's US connected stuff in possible direct conflict with both the principles of how we deal with intangible harm and also the presumptions of comity, in which we want all the countries to play nice, and extraterritoriality, in which the United States is presumed not to act outside of its sphere. So in perhaps direct defiance, although we pretend that it's not defiance, and we also say we can't understand why what you're saying is relevant when it's very clearly and obviously relevant, we come up with this decision. Now, I think the Supreme Court could have come up with this decision under the alternative rationale of saying there's a US judgment and we enforce the US judgment under the principles of the international treaty. So apparently there's an international treaty. So that would have been the easier way to decide this, right? There's an international treaty that says we're supposed to recognize foreign arbitration awards. And so the United States has entered a treaty. Therefore, there's no problem with comity, and therefore there's no problem with extraterritoriality, because the United States and Russia have agreed, apparently, that these judgments are to be enforced everywhere. Okay, so do that. So say, okay, this foreign arbitration award is enforceable in the United States. We've actually forwarded the principles of comity and extraterritoriality because treaty, and we recognize this judgment in the United States, and that because now there's an injury in the United States, the place of the underlying harm is now legally irrelevant. How about writing that? How about that? That'd be great. The place of the underlying injury is actually legally irrelevant. Sure, it all occurred in Russia. This is all Russia, all the way through, no problem. We get around that problem because the United States has this treaty with Russia that says we will enforce your judgments here. So this guy comes over here and we say, great, treaty. The United States and Russia agree. There is no problem now. There's no conflict. Comity is great. Extraterritoriality, great. Not a problem. Russia and the United States agree. We bring it in the United States. We apply your judgment. The place of the underlying injury is irrelevant. You are thwarting the United States judgment in agreements with a treaty that exists. And bingo, bango, bongo, that's an intangible injury. How about that decision? But the United States Supreme Court didn't write that decision. They wrote something else where they said, we can't understand for the life of us why you're bringing in this common law, which very clearly applies. And we also don't understand why we say this goes against extraterritoriality, even though we said RICO isn't have foreign effect. So, okay. So the United States Supreme Court probably comes to the right conclusion, but for very weird reasons. And that brings us to the end of discussion of this case.